You've heard it 1,000 times on TV. You have the right to remain silent. But what they don't say is this: if you don't use the magic words, that right doesn't do much for you. It's one of the most misunderstood rights in American law. People think silence protects them, but unless you're both in custody and being interrogated, your Miranda rights don't even apply. That's what we call them, Miranda rights. The right to an attorney, the right to remain silent. And even when it does apply, just staying quiet, that's not enough. The U.S. Supreme Court made that crystal clear in a case called Thompkins. The suspect sat silently through almost 3 hours of questioning before giving a one-word incriminating answer. The court said that because he never affirmatively invoked his right to remain silent, his silence meant nothing. The moment he spoke, even one word, he waived his rights. Let me repeat that. Under the law, silence is not the same as invoking or asking for your right to silence. It's not enough to hint or suggest. You have to be clear and unequivocal. That is, you're not wavering. You have to invoke your rights. You have to demand your right to remain silent. A man named Warren DeMesme learned that the hard way when the court absurdly claimed that they couldn't tell if he wanted a lawyer or a lawyer dog.
Courtroom Chronicles presents The Case of the Lawyer Dawg. All right, listen up. So there's this guy, Warren DeMesme, right? He gets busted by the cops and starts demanding his right to a lawyer during interrogation. But here's where it gets wild. Instead of saying, "I want a lawyer, man," or "I want a lawyer, dude," he goes and says, "I want a lawyer, dog." Now you'd think it's pretty clear, right? Well, hold on to your hats, because the cops pretended he was asking for a literal lawyer dog. They kept grilling him and didn't bother giving him the real legal help he asked for. Now, here's the kicker. When DeMesme's case goes to court, his lawyers argue that his right to counsel was trampled on. But guess what? The Louisiana Supreme Court wasn't having it. They said DeMesme's lawyer dog request wasn't a clear enough demand for a lawyer. Can you believe it? They're like, "Nah, sorry, dude, no lawyer for you." Well, fortunately, they didn't say, "Sorry, dog, no lawyer for you." Talk about a facepalm moment in the halls of justice. Courtroom Chronicles. The Case of the Lawyer Dog is brought to you by RHD Fence, the law office of Rick Horowitz. Fresno-based criminal defense at its best. If you're in trouble with the law, call 559-233-8886 now.
You'd think that if an adult can be denied his rights over a misunderstanding that basic, a child might get a little leeway. But no, not even close. In California, the courts often apply what I call selective skepticism, scrutinizing a child's words like a contract, looking for ambiguity, that is, something that's unclear, in the kind of statements no kid was trained to make. Take People v. Lessie. A 16-year-old boy asked to speak with his father before continuing a police interview. Sounds reasonable, but the California Supreme Court said, not good enough. They ruled it wasn't a clear request for a lawyer, so questioning continued, and so did the damage. Now contrast that with In re Z.A. There, a minor had already invoked his right to remain silent, but officers reinitiated questioning anyway. He repeatedly asked for his mother, and the court found that, along with his prior invocation and the officer's persistence, that was enough to violate Miranda and Edwards. Not because asking for Mom was enough by itself, but because the police knew better and pushed anyway. Here's the point. Whether you're a scared teenager or a grown man in handcuffs, the law demands that you say the exact right words, what I call the magic words, or your rights don't count. So what are those magic words? Let me show you exactly what you or anyone needs to say.
I am using my right to remain silent. I want a lawyer. I will not answer any questions without my lawyer present.
Then, stop talking. Stop talking.
That's it. Say it. And then stop talking. Don't say, maybe I should get a lawyer. That's unclear. Don't say, I think I'm done talking. That's unclear. And don't just sit there silently hoping they'll read your mind. They won't. They don't want to. In fact, if you want to know how crazy this gets, in the Thompkins case, a footnote in Justice Sotomayor's dissent mentions a man who said, I wish to not say any more. I'd like to be done with this. I don't wish to answer any more questions. And the court still decided that wasn't a clear invocation, because he also said, if you're implying that I've done it right before that. In other words, they said it was conditional. So don't be unclear. Just say, I am going to use my right to remain silent. Or say, I want a lawyer now. And then stop. And once you do invoke, they're not allowed to keep questioning you unless you reinitiate the conversation. But if you say nothing or say the wrong thing, you might be giving up more than you realize. So, do you really have the right to remain silent? Not unless you ask for it, not unless you invoke it. Don't assume the system is going to protect you. Learn the magic words. Use them. And then stop talking. This podcast is for informational purposes only. It is not legal advice. But if you ever do need legal advice, call me, 559-233-8886. Get a lawyer before you talk to the police. Otherwise, zip it.